It's the appointed time. We have a quorum. I call the meeting to order. Item 1. Information paper issued since the last meeting. No such paper has been issued by the Secretariat since the last meeting. Item 2. Items for discussion at the next meeting. Members have received the list of outstanding items for discussion. Our next meeting will be on the 16th of December at 4:30 p.m. The government has proposed the following items. 1. Law Reform Commission Secretariat, progress on the systematic review of statutory laws of Hong Kong. 2. The latest progress on improving the mechanism for mutual service of judicial documents in civil and commercial proceedings between the mainland and Hong Kong. Are we all good? If so, let's discuss those items. Item 3, report on the achievements of the Secretary for Justice-led delegation's visit to ASEAN member states. Let's first invite the officials to join us. Members, we have received the document. That's LC paper number CB-2 1467/2024-02. This is a paper from the Department of Justice. First, we welcome the Secretary for Justice and his team. We also welcome the Law Society of Hong Kong, who is joining us. Members, if you would like to speak on this item, please press the Request to Speak button. We will first hear from the Secretary for Justice, who will walk us through the paper. Chairman, members, Hong Kong is one of the most competitive economies of the world. We have close links with the trading centers elsewhere. We are a vibrant, convenient, and an open place for business. We have always leveraged our strength with support from our country and global connections. Now, for mainland businesses going global and foreign businesses investing in the mainland, we are a great gateway. The Department of Justice has led the delegation to visit different countries. We've met with people. Through different forms of exchange, we have promoted Hong Kong's legal and dispute resolution services. We've also explored opportunities for deepening reform. Now, from 24th to 28th of September this year, we visited Brunei, an ASEAN member state, and then we've also led the Hong Kong Bar Association and the Hong Kong Law Society on a visit to Vietnam and Malaysia, also ASEAN member states, to promote Hong Kong's legal and dispute resolution services. That's a way for us to step up exchange with those countries. We have enjoyed the support of the economic and trade offices in Jakarta and Singapore for the visit. We held more than 20 events during those visits to tell those countries about our unique strength with our common law system and also our strategic positioning as a legal and dispute resolution service center. We've also discussed Hong Kong's strategic role as a super connector and super value adder. Now, I want to highlight part of the visit. I also want to share the key outcomes of the visit. The first stop of the visit was Bandar Seri Begawan in Brunei. Last May, we signed a memorandum of cooperation with Brunei. We discussed that with the Chief Justice. We also discussed with the Attorney General of Brunei opportunities for collaboration. We've also talked to the local legal and dispute resolution sector, and that includes the Law Society of Brunei and also the Brunei Darussalam Arbitration Center. We told them about Hong Kong's opportunities, and then we visited Vietnam and Malaysia. We talked to the business chambers there. In Ho Chi Minh City in Vietnam, we held a event called Hong Kong, the Common Law Gateway for Vietnamese Businesses to China and Beyond. More than 120 participants from the legal, business, and other sectors took part in the event. They talked to members of the delegation. We told them about Hong Kong as the only common law jurisdiction in China. We told them about our unique strength in legal and dispute resolution services. We've also talked to the Vietnamese branch of the Ho Chi Minh City branch of the Vietnamese Business Chamber of Chinese Businesses. We've also learned about the demand for cross-boundary legal services. We also talked to the Vietnamese legal sector, and that include the Bar Association of Ho Chi Minh City and also the legal dispute resolution services there. We exchanged views on the latest development and also explored opportunities for future collaboration. In Kuala Lumpur of Malaysia, we took part in an event called Hong Kong, the Common Law Gateway for Malaysian Businesses to China and Beyond. We took part in this networking reception. I talked to Malaysia's Minister in the Prime Minister's Department, Law and Institutional Reform. We delivered a keynote address and a special remark. Addressing 150 participants, we shared views on different issues such as the top-notch legal services and arbitration services offered by Hong Kong, and also Hong Kong's role in contributing to our country's development. I also met with the Attorney General of Malaysia. We discussed issues of mutual consent. We witnessed the signing of 2 memoranda of understanding facilitated by the DOJ, and that is an MOU between the Malaysia's Asian International Arbitration Center and the South China International Arbitration Center, and also a supplementary MOU between the AIAC and the IBRAM International Online Dispute Resolution Center. We also met with the Malaysian Bar, the AIAC, and the Malaysian International Mediation Center. We learned about arbitration in Malaysia. The delegation also met with the Associated Chinese Chambers of Commerce and Industry of Malaysia. We also received a market briefing from the Standard Chartered Sadiq Malaysia to learn more about Malaysia's economy. The visit to the ASEAN member states was fruitful. Members of our delegation also learned about the legal needs and local culture of these ASEAN states. Members of the delegation met with their ASEAN states face-to-face, and that laid a solid foundation for future collaboration. This was also an opportunity for our legal sector to talk to the business and legal sectors in ASEAN so that they can explore future businesses. The DOJ will continue to tell good stories of Hong Kong and promote Hong Kong's role under the 14th Five-Year Plan, and that is Hong Kong's role and advantage as a legal and dispute resolution service center. We now come to Mr. Roden Tong, President of the Law Society of Hong Kong. Thank you, Chairman. On behalf of the Law Society of Hong Kong, we thank the Department of Justice and the Secretary for Justice for leading us on this visit to ASEAN member states as a way to step up exchange and collaboration with ASEAN. We have people from the local legal sector joining the delegation. They included specialists in litigation, commercial law, and arbitration, among other areas. There are mainland and Hong Kong businesses investing in ASEAN. Hong Kong's lawyers can advise and provide a range of services to these business leaders in a range of ways, and also we can also cover dispute resolution. So now we follow where the opportunities lead us. Where there is business, if there may be a need for arbitration services, and we go there. Hong Kong's lawyers are highly internationalized. That's where Hong Kong's lawyers can help Hong Kong serve as the super connector and super value adder. The local legal profession has an open policy. Now, overseas lawyers coming here can take part in an overseas lawyer's qualification examination, or OLQE, and then those lawyers can obtain a local qualification. In 2023, we had lawyers from 18 jurisdictions, 9 of them being non-common law jurisdictions. 244 candidates in total took part in that exam. That was the record high over the past 10 years, up 55% from the year before. As at the end of October, we had 11,000 practicing lawyers or solicitors and 971 law firms, 32 law firms, 1,500 foreign registered foreign lawyers, and also 82 foreign registered law firms in Hong Kong. Hong Kong had 38 foreign lawyers and 2 foreign law firms from ASEAN countries. Hong Kong has always had close ties with ASEAN. We have many cultural affinities. Many Malaysian Chinese speak Cantonese. These economic ties and cultural commonalities foster collaboration. Over the past dozen of years, ASEAN had been Hong Kong's second largest trading partner. In February 2021, our free trade agreements took effect with ASEAN, and that meant huge market and opportunities for Hong Kong. The visit to ASEAN was a fruitful visit. We had exchanged with the local legal professions. We told them about Hong Kong's unique strength under one country, two systems. We have a bilingual common law system. We also explained the legal issues that may arise from cross-boundary trade, and that gives them greater confidence in such business. In Ho Chi Minh City, we shared our insights with the local legal profession. We told them about the diversified legal and dispute resolution services. We also told them about the opportunities from the Belt and Road Initiative. Now, with 5 ASEAN member states and bar associations, we signed 6 MOU: Cambodia, Indonesia, Malaysia, Singapore, among other countries. We're also exploring closer ties with other places, such as the legal profession of Thailand. We are working to create more business opportunities for Hong Kong's legal sector. I now open the floor for questions. 3 members are waiting to speak. Ms. Eunice Yong, Ms. Carmen Khan, followed by me. Two panel meetings are happening at the same time, so some members may be jumping around, moving between 2 meetings, so you don't see a huge lineup here, so don't be disappointed. So let's start with Ms. Eunice Yong. 5 minutes. I'm pleased to see the Department of Justice play an active role, leading the Law Society and the Bar Association and other business chambers on visits to ASEAN and other Belt and Road countries to show the people there Hong Kong's achievement and policies. Business opportunities for Hong Kong's legal sector matter. ASEAN countries are close by. We need to help mainland businesses go global. That's also where business opportunities lie. Hong Kong's lawyers also get to practice in the rest of the GBA. That means lawyers who are qualified not just in Hong Kong but also in the rest of the GBA can go global, and we can showcase Hong Kong's strength. Whether it's a Hong Kong barrister or a practicing lawyer in the rest of the GBA, they can help mainland businesses go global through Hong Kong's professional expertise. I visited Belt and Road countries myself, including Kuwait in the Middle East. I have thoughts on helping mainland businesses to take their business to the next level, but there are bottlenecks to overcome. We know little about the laws of ASEAN countries. This visit covered Brunei and Vietnam. Visiting those places and signing MOU are a positive step. But for Hong Kong's legal sector to benefit from your visit, how do we get there? How do we ensure effective delivery of policies? We have to promote these things in the legal sector. We have these MOU and also exchange collaboration between business chambers. I know Mr. Roden Tong has played an active role. Now, people may wonder where they can access a lawyer in Vietnam or Thailand. Maybe the ETOs in those places can play a role. How can those ETOs coordinate or talk to different parties? The government is taking an active approach with actions. But the policies and measures have to hit the mark, and that is the legal sector has to be able to find the business opportunities there, and matching the sector with opportunities matters. The legal sector also needs local auditors and lawyers. Trust also matters. Any business ties the DOJ secured can be shared with Hong Kong's legal sector so that we know which local businesses in ASEAN are keen to work with us. And then we can talk to those partners. I think you have made your point clear. So I would like a response to see how we can make those measures work. So it's about making the most of the opportunities you have.
Secretary for Justice. I agree with what Ms. Young said. What is the role of the DOJ? We're like a matchmaker. We have arranged a series of events. We met with the business chambers along with legal and disputes resolution centers as well as arbitration centers. We asked the Chinese community there if they are making use of Hong Kong legal services. We tried to understand if there was any challenges, and we explained to them what we're working on. We try our best to meet the local demand in the 3 places that we visited. We told them what kind of services we can provide, and they told us what they need. I think that this will enhance connectivity among the places. The ETO there also helped us. Now we try to listen to the trade. I hope that they will let us know what they need. They can tell the Law Society, Bar Association, or the Arbitration Center. We hope that there will be a lasting effect to our visit, but it takes time. I think that we have to work on mutual understanding. We have to build a trusting relationship with ASEAN member states. We have to know each other, build trust. That's a process. Through this kind of duty visits, we want to facilitate understanding. We want to show our sincerity, but it takes time. Ms. Carmen Khan. Thank you, Chairman. My observation is the same as that of Mr. Roden Tong. I think that this term of the DOJ is actively promoting Hong Kong legal services, including legal disputes and resolution services, to other places. And mutual recognition of lawyer qualifications was being promoted in the Greater Bay Area. You went to Chengdu and the Middle East, and now the 3 ASEAN member states. Just as pointed out by the chairman, how do we make full use of our policies? And what area should we work on? I think that the DOJ is playing actually the matchmaker role. But I think that the trade should focus on certain areas. Now we have signed CEPA 2. We hope that the mainland enterprises will establish presence in Hong Kong and go global. That's how we can play a role as a super connector. For Malaysia and Vietnam, the same goals because the theme of this visit is to lead the enterprises there to mainland. Are we trying to attract them to establish a presence in Hong Kong? But I think that we should be more concrete in laying out our advantages. Will the DOJ explain about our advantages? That's my first point. After the visit, it is said that the three ASEAN member states are interested in the International Legal Talents Training Academy. Is this one of our focus? Are we trying to enhance collaboration on talents training? Is the academy one of our focuses? Secretary. Thank you. As for our focus, maybe I change the term. What is our selling point? In Vietnam and Malaysia, we held 2 forums. The theme is our selling points. The seminar is themed the Common Law Gateway for businesses in Vietnam and Malaysia to China and beyond. We want to highlight the common law systems that we adopt. What is the uniqueness to our city? We don't try to compare ourselves to other places, but we want to sell our uniqueness. We are internationalized. We have a robust legal systems, and we are protected by the basic law. More importantly, we have a pool of internationalized talents. Mr. Tong just gave us a series of figures. We don't just know about the laws, but we are familiar with legal services in other places because we have strong ties with international law firms. Under the one country, two systems principles, we have a lot of arrangements with the mainland, including the GBA lawyer qualifications system. If they make use of our services, they will be well protected legally while they make use of or seize business opportunities in the mainland. For enterprises that want to establish an office in Hong Kong, we promote free flow of capital and we protect private property in Hong Kong. And we also have a common law systems. These are our selling points and our unique advantages. These are our focuses. What is so unique about Hong Kong? And what makes us different from our other competitors? For example, our strong ties with the mainland legal systems. You also asked about the International Legal Talents Training Academy. That's one of our focuses as well. When we talk to the legal and business sectors in the 3 ASEAN member states, they said that they're interested in our academy. And capacity building is something that we both concern about. Upon the establishment of the International Legal Talents Training Academy, we receive inquiries from the mainland and other places. The challenge is how we cope with all the inquiries. Thank you. Chairman, I agree that we should identify selling points on the mutual or reciprocal enforcement of decisions and WOKE. I hope that there will be a song sheets for the Law Society and the Bar Association so that we can tell the same story. Ms. Doreen Kong. Thank you, Chairman. I'd like to talk about legal and disputes resolutions services. There is such demand in ASEAN member states. Now, in terms of introduction of arbitration and legal disputes services, do we have an edge? Now, regarding the demand from ASEAN member states, will the Secretary conduct market analysis and research to make sure that our legal services meet their demand? My second question. Just now, Ms. Carmen Khan also touched on this point, but the Secretary did not address it. That's about the International Legal Talents Training Academy. Secretary, in terms of training of legal talents and exchanges, will we enhance our efforts on these two areas? Secretary, thank you. There is great demand from ASEAN member states on arbitration services. They are developing their own capacity in this area. What is our advantage? We have a very mature arbitration system. Internationally, we rank the top 3 in terms of our the usage of our arbitration centers because we have great transport infrastructures and facilities. Arbitration doesn't usually or necessarily take place in Hong Kong, but our arbitration talents can go to the office of the clients to provide arbitration services. So we provide a takeaway service, so to speak. We want to encourage people to come to Hong Kong to use our arbitration center, but then at the same time, their arbitration centers can invite our barristers and lawyers to provide service to enhance their quality. While they can develop their services, our sector enjoy more opportunities. These are the ways to go. Second, on market analysis. Well, unlike economic figures, we cannot be very scientific in terms of our market research. I think that more importantly, we have to listen to the trade in the ASEAN member states directly and face to face. Of course, we can step up collaboration and exchange. My colleagues and I prefer to listen more to the trade because the nature of legal services is different from other modes of service. As for the International Legal Talents Training Academy, we promote it in the ASEAN member states. As I've said previously, we have different target customers. We want to help our country improve their foreign-related laws, but we also want to consolidate our status as a center for legal services. We help interested states to build their capacity. Through capacity building, we can tell other places that we have such a strength in talents training. We have to work out the details, but we want to be targeted in terms of the training that we provide. We have to ensure the quality of the training that we offer so that we can build a brand for ourselves. That's what we're working on. Next, Professor Priscilla Leung. Thank you, Chairman. First of all, I recognize the efforts of the Secretary for Justice over the past year. He has been leading the legal sector for multiple delegation visits. Now this paper is about ASEAN member states. I can share with you that recently there were mainland official units and enterprises that have reached out to us. They told us that when they go to unfamiliar countries, they're not aware of their local culture or legal systems, and that's why they sought us for help. for legal protection. They also wanted to know what reputable legal or law firms that they can use. Our country is promoting state-owned enterprises and community or private enterprises to go global, but they are not familiar with foreign laws. We may not be too familiar with foreign laws as well. We are familiar with common laws, but as for other kinds of legal systems, they come with local characteristics, and their public policy also differ greatly. I've come across a few of such cases very recently. However, on the other way round, when these countries come to Hong Kong, they are not familiar with our legal systems either. Our legal system is widely recognized. How do we connect these two parties up? I have this experience together with these experts from these 30 countries, including Malaysia, Vietnam, and Indonesia. They advocate for mediation, just like us. People are worried about going to the court because they are not sure if the interests of civil or commercial cases would be jeopardized. And a lot of parties have a different kind of worries. So I think that we should promote our international organization for mediation so that we can build a kind of culture for mediation. There is an appeal board in WTO that is internationally recognized. If we can establish a repetition for international organization for mediation, then we may be able to overcome systemic differences in different places. If we can resolve mediations, then we can establish a good repetition.
Arbitration is more familiar territory for us. Going to arbitration is better than going to court, because going to court is very much uncharted territory, and businesses worry about that. We can be this middle person. Our legal sector is putting in the work, creating this bridge will be helpful. Now we can find reputable local partners. They can be our guide in those markets. Mainland businesses worry about legal protection in contracts or in lawsuits in those countries. So with the support of our legal sector, and we have been promoting international arbitration, and we have to tell more people about the services we offer, and that will be beneficial to both sides. So that's mostly a comment from Professor Leung. If there's no response, I will move on with the questions. I have two questions. I want to start with the first one and see how much time we have left. ASEAN is Hong Kong's second largest trading partner. I am very grateful to the Secretary for Justice for leading this delegation and promoting our legal and dispute resolution services. The paper says that two MOU were signed, one between the AIAC and the South China International Arbitration Center, and the other one between the AIAC and the EBRAM. The policy address this year proposed sports arbitration. Malaysia's arbitration center offers sports arbitration. So my question for the SJ is, Have you discussed sports arbitration with Malaysia? Are there things we can learn from Malaysia to speed up our own development? Is there room for cooperation between Hong Kong and Malaysia? And if so, where can we work together? Chairman, you raised a great question. I asked about this specifically during the visit. The center in Malaysia is called Asian International Arbitration Center. They have a set of rules on sports arbitration. Now, those of you who were on the visit can testify to this. I asked about the features of that set of rules. There are things special to sports. First, speed matters. I asked what distinguishes sports arbitration from ordinary arbitration. What are the ingredients of success? And Malaysia told me a few points, and we can learn from this. First, efficiency. Quick results matter for sports arbitrations because it may be about whether an athlete can contest on behalf of a country or an association. The match may be a month from now. You cannot wait a year for the outcome. I know there are international sports associations that expect outcomes in a matter of days. So we have to ensure quick outcomes for sports arbitration when we devise our own rules. The second point is about who the sports arbitrators are. There are different kinds of sports. Say, some arbitrations have to do with doping. And then there are different sports, each with something specific to that sport. Outsiders know little about the root of the issue that arises. So we need a panel of people who can serve as sports arbitrators. That matters. And that means you have to cover at least the mainstream sports. So I'm just giving you a couple of examples off the top of my head. We also discussed many other issues. So I looked at the rules in Malaysia to see what we could learn from. I believe Malaysia's rules also incorporate elements from other places, but I just shared 2 points that really stuck in my mind. Many from Hong Kong's legal sector were also on the visit. We're having internal discussions about this matter as well. As the chairman said, we want to put in place a system for sports arbitration. But for that, we have to work with the industry. Now, the SFNOC just announced a new code of governance. In that code, there are appeals mechanisms. The appeals mechanism has to interact with the future arbitration system. So we have to put our heads together and we have to work with the stakeholders. And that means the sports sector, the legal sector, and other stakeholders. Malaysia's approach will be something we will learn from. So I will save my second question for the second round. Mr. Holden Chow. Thank you, Chairman. I thank the Secretary for Justice for leading this delegation to ASEAN. We need such delegations, and we can see the outcomes. The Law Society also helped out. I have more of a suggestion to make. There were past visits led by the SJ and the Law Society. The outcomes were great, but there's a constraint on the size of the delegation. in the legal sector, there are international law firms. They may be represented on that delegation. But then for small and medium law firms, they are also keen to tap business opportunities outside Hong Kong. Starting from last year, we have had a professional services assistance scheme. So $200 million in funding is available for professionals to visit other places. That's to promote Hong Kong's professional services. I believe this scheme falls under the Commerce and Economic Development Bureau. So can the Department of Justice work with the CEDB and promote that scheme in the industry? I know the Law Society is well known, but can we also get other groups involved? I know there are key members of the Law Society. They may be able to cascade that information to different members of the legal sector so that more people apply for this scheme. I believe that's the whole point of the Professional Services Advancement Support Scheme. The visit produced good outcomes. But can we get more people from the legal sector to go on their own visits by applying for this scheme? And maybe the SJ can provide contact in ASEAN to our legal sector so that our local sector can talk to their peers in those countries. We're not looking for instant business, but over time you will find business. And then you can have business deals. So that's my suggestion. Maybe the SJ has ideas to share, so a brief reply would do. Now, I'm not familiar with that support scheme, so I will find out more about this. Now, one comment on principle. Mr. Chow made a good point. Law firms come in different forms, large and small. The delegation we had tried to be as inclusive as we could in the kinds of law firms that took part. So there were law firms who were old friends, and there were also new joiners. On this delegation, we had the sole proprietorship, a small law firm. And this lawyer happened to be legally qualified both in Hong Kong and in Malaysia to practice. So we also did market survey. We did research on the market. We tried as much as we could to get different kinds of law firms to be on the delegation, because only then could we tell people about our legal services. We have large law firms and also boutique law firms. Hong Kong is like a food court. Whatever your preferences may be, there is something for you. That's the impression we want to convey. We also want to let different members of the legal sector to be on the delegation. As for the support schemes, we will talk to the relevant policy bureaus. Speaking for the second round, Professor Priscilla Leung, 3 minutes.
Thank you, Chairman. I fully support what Mr. Chow said. In this year's policy address, when I met with the chief executive, I raised the same point. We went to the South Africa to attend an international conference. It's difficult enough for us to apply for allowance, and the application process took a long time. But that was a great opportunity. I think that it was called SPARS. They gave us 1 hour and a half to talk about one country, two systems and our legal services. We are such a great city. On the community level, we have great international network. Eventually, I gave up on attending the international conference, and I relayed the issue to the chief executive. Hopefully, we can relax the barriers that we have. Everyone is busy, and as long as the application process is complicated, we usually give it up. And sometimes this is how opportunity goes to waste. The scheme is a great one, but I think that we should expand the scope of it. That's my first point. Second, I appreciate the Secretary's point on sports arbitration. I'd just like to add on what I just said. When the institutions, culture, religion, and legal systems of the ASEAN member states are so different from ours, while we may share common Asian values, can we establish standard rules with them? Say, for example, a model rule on environmental protection. We can set up common rules so that as long as there's dispute, it's easier for us to resolve them. I think that we should look into it. We're not asking us to align everything, but we should set up rules on environmental protection, ESG, IP, so that we have common ground to work things out. I think that Vietnam wants to work with Hong Kong. I know a lot of Vietnamese lawyers. They told us that is more difficult than they thought to apply a visa to come to Hong Kong. That's my comment. Thank you. Thank you, Professor Leung, for the comment. Any response? Thank you. Just now, Mr. Chow talked about past funding. I believe that's what he was talking about. Past funding is nothing new. All along, it has helped legal sector to conduct visits. As for actual operation of application, I understand that there is room for improvement. Together with the relevant government department, we try to enhance the application process for the funding and the reimbursement procedures. We will continue to improve it to make it more efficient. As for the model rule, I will consider it. Regarding the visa for Vietnamese lawyers, that's what they told me when I went on to the visit, and I talked to the relevant policy bureaus on it. Actually, the Security Bureau consider a basket of factors to make it more convenient for the legal sector in other ASEAN member states to come to Hong Kong. The relevant bureau is aware of the issue. Next is my turn. In UK, there was a survey saying that Hong Kong is one of the most popular arbitration centers. We rank the third. We have a one country, two systems, and we have an independent legal system. We are a super connector, and we are a super value adder. We rank the third just after London and Singapore. During your delegation visit, have you collected the views of the ASEAN member states? And do you have a plan to encourage more ASEAN member states to make use of Hong Kong's arbitration and legal dispute resolution services? Thank you, Secretary. Thank you. We try to learn what arbitration centers the ASEAN member states are using. One objective fact is that some ASEAN member states are more familiar with Singapore because of the geographical location and historic reasons. My impression is that ASEAN member states are more familiar with Singapore compared to Hong Kong. That's my impression. That's why a lot of ASEAN member states at this point of time may prefer Singapore to Hong Kong. That's just my impression. Currently, ASEAN member states aren't too familiar with us. But then, of course, there are a lot of different countries under ASEAN. Brunei is a small country, but they're familiar with our legal systems because some judges work in both Hong Kong and Brunei, and we have close legal collaborations. That's not about the scale of the country. Malaysia also adopts common law systems, and we have diverse collaboration. But for Vietnam, which is not a common law jurisdiction, because of the language barrier and the difference in terms of legal systems, we have to work on a lot of things. So I think that we have to look at different member states separately. But then, of course, I want to visit more ASEAN member states in the future. Indonesia is where I want to visit. But then I have to look at my own work schedule. There are other countries in ASEAN. Our country is working with Laos, Cambodia, and the chief executive also visited those two countries. With the development of the Belt and Road Initiative, I believe that there will be demand from these two places. Together with different provisional government in the mainland, while I met with Guangxi Ministry of Law or rather the Department of Justice there, they said that they're promoting their services in different ASEAN member states. So we can either directly work with ASEAN member states or we can collaborate with those states through our mainland entities. So, well, thank you. Guangxi and Indochina have a very close tie with each other. Last member to speak, Ms. Carmen Khan, for the second round. Thank you. Chairman, well, haven't listened to Chairman and the DOJ's. The President of the Legislative Council led a delegation visit to Indonesia and Malaysia as well as Singapore. From the visit, my observation is more or less the same as that of the Secretary for Justice. Different ASEAN member states have different level of understanding of Hong Kong. Brunei, Malaysia, know Hong Kong better than Vietnam, for example. What is our next step? I'm not trying to add to your workload, but through the visit and having listened to the reply from the Secretary for Justice, I think that we should follow up on the visits given our ETO in those places. Say, for example, in Guangxi, and ETO can work on these areas. The CEDB has an ETO in some of the ASEAN member states. Maybe we can establish a working group to create a song sheets that stipulates our advantages. I've always been asking for song sheets for our ETOs because as a lot of business chambers and religious bodies in ASEAN member states aren't really familiar with Hong Kong. We, for example, have REJ, and we have reciprocal enforcement of just judgments with the mainland, along with other advantages. Hong Kong is a major gateway for these member states to enter the mainland market. Any response regarding song sheet? As the representatives of the ETO has just returned to Hong Kong and we had a meeting, we have reached a consensus. We will be creating a song sheet to facilitate promotion. The problem is how long the song sheet should be. It shouldn't be a 1 to 2 hour orchestra, but we have to be detailed at the same time. Thank you, Ms. Khan, for the suggestion. Thank you. Next item. Latest development of the judiciary's use of technology in court operations. Thank you, Secretary for Justice, Mr. Tong, President, and your team. Members, you would have received 2 sets of paper, LC paper number CB bracket 21467/24 bracket 03 and bracket 04. They are paper provided by the Judiciary Administration and the background brief prepared by the Legislative Council Secretariat, respectively. Members, if you would like to put questions, please press the button. Welcome, Judiciary Administration, Judiciary Administrator Ms. Ethel Learn and her team, as well as representative from the Bar Association and the Law Society. I will first ask, my apologies, I will wait until you're ready. Please let us know. Okay. Would Judiciary Administrator please brief us of the paper? Thank you, Chairman, and thank you, members. I'd like to brief members on the paper that was submitted, that is the latest developments of the judiciary's use of technology in court operations. The primary role of the judiciary is to uphold the rule of law. In order to perform its judicial role and functions more efficiently, the judiciary has been taking forward a series of technology initiatives to facilitate the conduct of court business. Major initiatives have been set out in the paper submitted. Now I will highlight a few important measures and the progress. First, I'd like to talk about the Integrated Court Case Management Systems, ICMS. That's one of the major initiatives under the Information Technology Strategy Plan so that court users can submit documents electronically. They can also access filed documents as well as conduct e-payments. ICMS is implemented by phases. The first phase has been implemented in the District Court and the Magistrates Court since May and December 2022. The electronic modes can be applied to personal injuries actions, tax claim proceedings, civil action proceedings, and employees' compensation cases in the District Courts, as well as summons cases in the Magistrate Courts. In October 2024, we have expanded the ICMS to a small claims tribunal, bulk claim cases. And from early 2025, we extended to Court of Final Appeal, the High Court, and the non-summon courts of the Magistrates Courts, MC. As at October 2024, we have a total of 522 court users, including 417 law firms that have registered for accounts under the ICMS. Through the ICMS, the number of new cases have gone from 13% as at January 2023 to 60% as at October 2024. The judiciary has been promoting the ICMS. We have offered a fee concessions of 20% and established a dedicated website as well as a ICMS help center to provide assistance. We have conducted briefings and demonstration sessions for the legal sector. And in early 2025, we will introduce a deposit account so that corporate users can make non-interest-bearing prepayments. Also, the Judiciary plan to, starting from 2026, mandate the use of ICMS for all legally represented litigants in respect of case types where the electronic mode has been made available. And to encourage more people to make use of the ICMS, when the external functions have been implemented in the designated legal proceedings in the High Court, we will ask the litigants to submit an electronic copy of the document in USB.
I now turn to remote hearing. Remote hearings are a key ongoing priority for the court. But to ensure a clear statutory basis for such hearings, we will submit the court remote hearing bill. With this bill, we want to set out clearly how matters will be dealt with during such hearings. In June 2022, we conducted a 3-month public consultation. In May 2023, we consulted this panel. Based on the feedback, we have decided on the content, and in December, we will introduce it to the Legislative Council for the first reading. Now, on voice-to-text technology, we have been using the technology to record court proceedings. We have been exploring the products available on the market, and we have been using those to develop the system for the court to enhance our efficiency in making transcripts. After 10 months of testing, and that included testing with Cantonese and English, the accuracy has gone up gradually from 60% to 80%. Starting from December last year, judges and judicial officers have been able to use this VTT system for note-taking to facilitate judgment writing. We will also take an incremental approach to trial the use of the text from the VTT system for making transcripts for certain CFA and High Court cases. Now, to ensure public confidence and enhance transparency, we will arrange live broadcasting for certain court proceedings. From January to May 2024, there were live broadcasting sessions for 4 cases. The proceedings went smoothly. After those court proceedings ended, the proceedings were put on the website of the CFA for a short time for public access. For those 4 sessions, 17,000 viewers watched the live cast. 9,900 viewers watched the webcast playback. The Judiciary is looking at the experience to decide on the way forward for live casting of court proceedings. I now turn to generative artificial intelligence. The Judiciary has looked at the guidelines in other jurisdictions. In July this year, the Judiciary promulgated the first set of guidelines on the use of generative AI for JJOs and support staff. The guidelines set out the principles for JJOs and support staff to take a prudent and responsible approach to the use of AI in their work where appropriate. In other words, in any case, JJOs must not delegate the performance of the judicial function to generative AI. Any material obtained from generative AI is still something that JJOs are personally responsible for. Generative AI is helpful when it comes to summarizing and administrative and clerical tasks. But we have yet to see a generative AI model that can verify information with a built-in checking function to ensure accuracy and reliability when it comes to professional legal materials. The Judiciary does not recommend the use of generative AI for legal analysis, including the writing of judgments, but we will be closely watching the development of generative AI and the experience of other courts as we amend the guidelines in a timely way. I now turn to court facilities. 180 courts, or 80% of our courtrooms, have the latest facilities that support various proceedings done electronically, video conferencing, e-bundles, digital evidence, and exhibit handling, as well as the broadcasting in courtroom extension. In the West Kowloon Law Court and the Wan Chai Law Court building, the facilities I mentioned are in place. There are also extra systems such as multi-language simultaneous interpretation systems, 8-channel audio recording capabilities, and the voice-to-text system integration. In May this year, the Finance Committee approved the funding for a project about the I&T systems for the District Court building on Caroline Hill Road. Our goal is to implement all those arrangements by the end of 2027 to tie in with the building. Now, on IT security enhancement in the Judiciary, based on the government's latest IT security policy, the Judiciary is updating its own IT security policy and also stepping up measures. And this includes non-judiciary designated systems cannot store or process data related to the judicial work. And on the judiciary's systems, no one can use private personal webmail or public cloud storage. We will continue to use technology to enhance our efficiency. We will stay vigilant to the security risks from security in our line of work. Thank you. Thank you. We will now invite Mr. Martin Wong from the Hong Kong Bar Association. Please stay within 5 minutes. Thank you. We want to make 3 points. First, it's about the integrated court case management system. We're all for efforts on this front by the Judiciary. We received consultation papers from the Judiciary for our views. Every time we considered our members' views and then we gave a response to the Judiciary. The work has progressed in an orderly manner. Now that arrangement has been extended to the High Court. The system now covers a wider range of services. Now there is e-service between parties. It's not just between courts, but also between parties. In the case, we welcome that. We hope the work can continue in such an orderly way. Our second point is about remote hearings. Just like the first point, the Bar Association played an active part in sharing its views. From what I've seen myself, I can see the High Court can hold remote hearings in all its courts. More judges now accept remote hearings where appropriate. That's a positive development. This will mean smoother proceedings. Our third point has to do with generative AI. This is a hot topic. There are many factors to weigh for the Law Society and the Bar Association. The technology is moving fast. Many service providers are in the market. They have come to us telling us about their technology and services. But not many members in our association adopt the technology. I believe that's down to two interrelated factors. One, reliability. Some of our members remain skeptical. When barristers go to court, they have to put in the submissions, they have to do the legal analysis. We're not confident enough in that technology. Barristers still serve as their own gatekeepers, so few barristers adopt the technology. But our association will closely watch where this technology goes in the future. When the moment is ripe, our association will consider issuing guidelines to our members to help them make better use of the technology in a secure way. So those are my points. Thank you, Mr. Martin Wong. We now come to Mr. Roden Tong. Please stay within 5 minutes. Chairman, Judiciary Administrator, members, Ms. Esther Leung just reported on the latest developments in the use of technology in court, and that includes the integrated court case management system, the registry services, and the voice-to-text system. Technology moves fast. The Law Society believes we should move with the technology. As at the 31st of October, there were 971 law firms in Hong Kong. The paper says 417 law firms had signed up for the ICMS. In the early days of the ICMS, we explored the reasons for the low uptake with the judiciary. Law firms could deposit documents with courts or file documents with the court. Still, the law court had to send someone to take the documents to the court, so that meant limited savings in time. Many jurisdictions have already allowed e-filing of documents. E-service has been in place in those jurisdictions, so the Law Society suggests that we should do e-filing and e-service on the ICMS. Some law firms told us. Now, when a writ of summons is involved, that writ cannot be downloaded right away on the ICMS, and law firms cannot tell when they can find it. When you're at the registry, you have someone there verify the document for you, and the writ can be served right away. The sector welcomes the use of new technology. The sector is using the ICMS. We look forward to further improvements, enhancements in the system so that we see greater efficiency. The judiciary is planning to mandate the use of the ICMS by 2026. I hope that the self-service kiosks at the registry can also be accessible to people from law firms. There are micro courts in the mainland. People can serve and file documents on those platforms, and people can see all of the documents at a glance. In civil cases where the court finds it appropriate, neither the plaintiff nor the defendant has to appear at court. I hope our judiciary can also look at the experience with technology in the mainland and in other jurisdictions. And early this year, We also witnessed the use of the voice-to-text system. The VTT system helped judges take notes in real time to help them write their judgments. The transcript made in real time automated the recording of court proceedings. Our members told us in the mainland law court, they have giant screens. You see the text show up on the screen right away. Both parties can correct the text right away. This is to ensure a faithful and accurate record of court proceedings. Real-time recording with the VTT system can lead to greater efficiency in civil and criminal cases, and this applies to district court cases and magistrate court cases. This can shorten the time cases take, and this can help fix the backlog. Our courts have been using the DART system for years, digital recording system. Parties can apply for the text, the transcript prepared by DART. But preparing the transcript is a labor-intensive task, and you need a transcript preparer. And because of the huge volume of cases, the applicant has to wait before getting the text. We hope that the VTT system can become more mature so that the system is not just there to help judges with note-taking, but also help the courts prepare the official transcript through the digital audio recording and transcription services. The Law Society hopes the Judiciary will continue to remain in touch with the Law Society to enhance the efficiency of the court.
Thank you for the Presidents of the Law Society's detailed suggestions. There are 4 members who have pressed the button: Mr. Dennis Leung, Ms. Maggie Chan, Ms. Yong Ha-yan, and Mr. Holden Chow. Mr. Dennis Leung. 4 minutes, including question and answer, please. Thank you, Chairman. Regarding the adoption of digitalized systems in the court, I support it. But as regards progress, I hope that the Judiciary will take into account the comments of the Bar Association and the Law Society. Maybe the Judiciary can enhance collaboration with them. Having listened to the 2 presentations given by the Bar Association and Law Society, I wonder why the usage rate is so low. Did the law firms not want to use it, or did they find the systems not useful? So is it the case that the systems cannot meet their demand or needs? To put it simply, are the functions not sufficient? I think that the Judiciary have to work on it. So I wonder if the Judiciary has engaged an expert to work on the systems, or are they relying on the IT department of the government? It is said that the Judiciary offer a fee concession of 20% for the use of ICMS. So I wonder how much income has been forgone with the discount. I see that manpower and resources can be saved in the paper, but I wonder how much manpower and resources have been saved exactly, given the fee concession. Thank you. The last line is a question. Please answer that. Thank you. Under the ICMS, in 2022, we started implementing it in phases. In the first phase, we only implemented in selected cases under the district council. That's why the utilization is low. All legally represented litigants and non-legally represented litigants make use of the systems. For non-legally represented litigants, they don't usually come to the court to create a case, and we don't plan to mandate the non-legally represented litigants to use the system. We just want the legal sector to start using the ICMS, and we will mandate it for selected cases. But the change would take time. We note the points of concern from the sector. Now, the system has not been implemented in the High Court yet. So some law firms may think that they have to submit physical documents for some of the cases. The utilization rate is going up, but that's because we implement the systems in phases. As for the e-records, well, we engage experts to create the system, and the IT systems operators also help us. But our IT colleagues under the Judiciary come from the Digital Policy Office from the government. So the system is very stable. During the course of development and of the system, we have been collecting views from the Law Society and the Bar Association. We're going to mandate all legally represented litigants to use the ICMS, and we still have to work out a lot of details with the two associations and societies. Hopefully, we can boost the utilization rate. Next, Ms. Maggie Chan. I appreciate the JA and the Judiciary's efforts in the promotion of the ICMS. As for the utilization rate of the system, I'd like to share with you my suggestions and my suggestions on the collaboration between DOJ and the Judiciary. I used ICMS before, and I found it very useful. And I recommended the systems to my lawyers and their secretary along with their teams. I asked them to adapt to the systems. But for small and medium law firms, they don't just upload the documents, but we have to make sure that we have robust cloud services and scanning service. And we also have to deal with the issues of bulk storage as well as the servers for the cloud services, as well as the systems. A law firm may need to spend a lot of money to enhance their infrastructures. That's why small and medium law firms find it difficult to use the ICMS. That's why we have to support these law firms. For e-filing and e-payment under the ICMS, there is a fee concession of 20%. I wonder if you can provide a greater discount. I hope that you can offer, for example, a fee concession of 30% or 40%, because we have to spend money on improving the infrastructures before we can use the ICMS. As small and medium law firms need support instead of training. We need support on manpower and resources. The judiciary is going to establish a working group on the promotion of use of technology in court operations. There is no member from the judiciary in the working group yet. This platform is to collect views from the trade and to relay them to the judiciary. We want to promote the use of ICMS so that the trade can be digitalized. These are my questions. Sorry, I also like to talk about the transcript. Can you also offer a concession for transcript services? Only the last one is a question. Please be very brief because time is up. Thank you, Chairman. Regarding the comments of Ms. Maggie Chan, we will consider it. As for the transcript services and the fees, the VTT will be used to allow our contractors. Well, we will allow our contractors to make use of VTT to produce their transcripts. Hopefully, we can shorten the time for the preparation of transcripts and we can lower the cost for the sector. Hopefully, if the contractors can make use of the VTT, we can lower the cost. Ms. Yung Ha Yan, thank you. I am glad to see that the court is going paperless and they are using IT systems to solve problems. And there will be a mandatory use of the ICMS in the future, and there is a timetable for that. Are you going to mandate all legally represented litigants to make use of the ITMS starting from 2026? Because we are at the end of 2024, and in 1 year time, are we able to mandate all lawyers and barristers, as well as their barristers' chambers, solicitors, to make use of the ICMS? Because for ICMS users, they still have to submit physical copies of the documents to the court. Are they still required to do so? And second, about translation. We've talked about the VTT a number of times. We think that there is a need for such a technology. Now, the JJO can make use of the VTT on a trial basis, but if we allow the plaintiff and the defendants to comment on the transcripts and its accuracy, that will serve as a great demonstration of the technology. This will show that the technology doesn't only serve the JGO but also the lawyers and barristers. Hopefully, the VTT can shorten the time for judgment writing and encourage more talents to join the judiciary to solve the manpower shortage issue with our JJO establishment. We have a lot of VTT systems on the market. Can we make use of it in the court? Can I turn on my mobile phone and turn the voice into text on my mobile phone? This will help the legal sector in handling our text as well as transcripts, because we are unable to have real-time transcripts. Only the court is allowed to record the voice in the court. How do we ensure that both the plaintiff and the defendants can make use of new technology?
I think there was a comment that the transcript generated by the machine is only 80% accurate. Is it true? Now, to respond to your questions, the voice-to-text system is only 80% accurate. But we're drilling the system every day. With practice comes greater accuracy. So the accuracy won't stay at 80%. Now the outcome is 80% accurate. The Legislative Secretariat also has its own voice-to-text technology. We will look at electrical system. If there are more accurate systems, we may adopt that system to further enhance the accuracy of our transcript. We have received this feedback when we had a visit at the court. We keep an open mind about this. Once the technology matures, we can consider ways to open up the system. But we have to make it clear as to the legal status of this kind of note. Once we have the principle in place, and then we can explore what we can do to help our legal sector about getting a record of the proceedings. It's okay to give us an 80% accurate transcript, and then the parties can amend the text. We don't need, and it's impossible to get a copy with perfect accuracy. The parties can agree on a transcript. The parties can decide on a copy they're both happy with. I think you made your point clear, so the judiciary will consider this. Mr. Holden Chow. Thank you, Chairman. I appreciate the arrangements about the ICMS. The system has improved gradually. More people in the legal sector are adopting the ICMS. The judiciary wants to mandate the use of the system by 2026. We're heading towards that direction. I do have a question, and this was mentioned by Mr. Rodentong. Even with the ICMS for filing, service of documents on the other party has to be done in the old way. So how is the work on this front coming along? Now, this may be a far-fetched point, but I want to say this here. Since we have this system and we are going electronic, so does that mean for all future filings, we can take care of everything on the same electronic system? Is that what we are considering? We have had discussions about this. It's about e-service. But let's keep up with the times. This is a great opportunity. We have this integrated court case management system. Now it's just about submitting documents to the court. So can we take this opportunity? Can we be bold? For all service in the future, can we use this electronic system as well? The approach today is time-consuming and labor-intensive. Small and medium law firms are retraining their filing clerks. These law firms are trying to give filing clerks other work, other tasks, instead of just having to send people to the court to retrieve or recall files. So I want to hear from the judiciary what ideas they have in mind. So that's mostly a suggestion. we have heard this kind of feedback from the sector, like from Mr. Rodentong. Back in the days before 2020, someone raised this matter. We did not include the service of documents between parties when we were developing the system, because the system, when it was under development, was about parties filing documents with the court. We were going from paper-based documents to a paperless approach. It was a major step. We did not include service between parties. We had to separate documents for the court and documents between parties, because the documents between parties cover those that may not be filed with the court. The government may be a party in some cases, but we're not considering opening up access to departments at this point yet. The ICMS is a huge system. It holds a vast amount of documents, including sensitive and personal information. If we open up access to the system to everyone, that will involve a huge amount of data transmission, and we will have to enhance the information security of the system as a whole. So there are many factors we have to consider before we can implement the suggestions we get, but we do note the ideas, so we will explore these ideas. But we will take this first step. First, we get the legal sector to use the system. And then for e-service, that may warrant further exploration and communication with the sector in greater depth. Ms. Carmen Khan. My first question has to do with remote hearing. Paragraph 12 of the paper says the Judiciary is finalizing the bill. The bill will be tabled in December, and I believe I heard early December. So how will the Judiciary explain the bill? Here it says it's about removing the restriction where remote hearings cannot be adopted in criminal cases, and there will also be references to how remote hearings will be conducted. We have to make it clear to the public that remote hearings are about greater convenience without compromising justice. So this needs to be explained to the public. Now, the use of AI is also top of mind for me. The guidelines are welcome. The ITIB has also said on the Inner Hong Kong platform, there's a center for generative AI, or Hong Kong Guy. So for this system, will the Judiciary adopt Hong Kong Guy? The government said it would first do a trial and then it would adopt the system. First, remote hearings. On the 4th of December, the bill will be presented for first and second reading at the council meeting. We have taken on board views from this panel and the legal sector in drafting the bill. That bill, once enacted, will provide a clear basis for when a court can order remote hearings. The bill will also govern the cases and hearings that can be covered by remote hearings. There is a restriction where criminal cases cannot adopt remote hearings, but there are different hearings other than trials for criminal cases. For the straightforward, less contentious hearings in criminal cases, they will be covered by remote hearings. Civil cases can already adopt remote hearings now, but in half a year's time, we will step up promotion. Remote hearings can also apply to other forms of hearings, so we will do the preparations. Now, on the guidelines on AI, this is our first set of guidelines. We want to lay down the principles. So, legal analysis and judgment writing are highly professional legal tasks, so these tasks cannot be done with AI. The AI is a tool that can be used, but the judicial office cannot be delegated to AI. If there are AI tools suitable for non-judicial clerical tasks, we do allow judicial officers to use those tools with care. Now, on Hong Kong Guy, we may get our support staff to try the system and use it where appropriate. Mr. Porter. Getting started is always the hardest part. Back in 2013, there was a strategic plan. We put $680 million into the project. The project went so slowly that you drew the flag of the audit commission. And then with the effort of the administrator, the project went ahead. I want to find out about the frontline condition. Mr. Roden Tong has spoken. The legal sector is more concerned about the problems on the ground. First, it's about registration. As at October 2024, 45% of law firms had signed up for the system. For new cases, 60% of such cases were covered by the system. For new filings, it's 60%. But for cases where the subsequent steps were also done on this system, do we have the figures? So once you start a case on the system, do the subsequent steps also happen on the system? Mr. Roden Tong made a good point. Without e-service, without sealing, even a 20% off would do little to get law firms to sign up. Ms. Maggie Chen suggested greater discounts. The discount means little. What really matters is greater speed in service and sealing. That would be a greater incentive for law firms to use the system. So I hope the administrator can take note. On the voice-to-text technology, I visited a district law court. I wondered why we could not open up the voice-to-text technology to court users as well. Ms. Eunice Yong also made this point. We're not asking for perfect accuracy certified by the court. We're simply looking for a transcript agreed on by the court and both parties. Lawyers have a hard time jotting the proceedings by hand. Having this transcript prepared by the court will be helpful for frontline court users. Mr. Roden Tong also mentioned mainland examples. You have a giant screen, the text shows up on the screen, people can see and they can correct the text right away. maybe we can do that. Let's encourage the use of the technology. You have a year's time, and that's not a lot of time. More than half of the law firms have yet to sign up, so let's speed up the work.
都多謝。
Please be succinct. Thank you. I thank Mr. Chair for the suggestions. As for service of documents, as I've mentioned, we have to create incentives for law firms. But under ICMS, it's difficult for us to add such a function. We will consider the possibility. As for the voice-to-text technology, on the one hand, we try to enhance the accuracy of the systems. On the other hand, we will try to share the transcripts to the sector, or a record instead of a transcripts. But that record is not 100% accurate. We will look into the suggestions. As for the registration rate, is not high, but in the interim, we will continue to promote the technology. The more people know about the systems, the more users we will see. But as for e-search, that is, for e-search done under the ICMS, that amount to 9,000, and the transactions amount to 20,000. In 2026, we will mandate the use of ICMS, but it doesn't mean that all cases have to use ICMS. We may be adopting or implemented the system in phases. There could be uniqueness to some case. And next, Ms. Maggie Chan, 3 minutes, including question and answer. Thank you. Now, I'd like to ask about generative AI. The JA said that because of the maturity of the systems and the accuracy, generative AI is not recommended to be used in the judiciary. So I wonder if the judiciary is actually using generative AI. My second question regarding the guidelines on AI. That's great for now, because we're just at the starting stage of the adoption of the technology. Will we include the analytics summarization of functions of AI? Can we train our AI in our basic law or constitution? Because we have to enter such information to train them AI. If we don't train the AI in our basic law, constitution, then the results generated by the AI will fall outside our legal systems. JA, thank you. Regarding the first set of guidelines on the use of generative AI, that targets the use of existing generative AI. Users could be JJOs and support staff. We set out what they should pay attention to when they use the existing generative AI. We're not trying to create a new AI model on our own. Because generative AI is a textual computer systems of sort, these systems try to predict, and there could be risks, and there could be inaccuracy, bias, a problem of being misleading. That's why we have to set out a guideline for the JJOs and support staff. When they use generative AI, they must verify the information generated by the AI carefully. If there are systems that are more reliable, we will encourage our colleagues to use it. But sorry, are you going to encourage your colleagues to use it? Well, apart from judicial work, we encourage our colleagues to use AI for administrative and clerical tasks, but that's limited to drafting of speeches, for example, writing of emails, memoranda, and letters. But we should not use generative AI for illegal analysis or judgment writing. Mr. Paul Chair, for the second round, 3 minutes. Thank you. I'd like to follow up on the mandatory use of ICMS in 2026, because I want the trade practitioners to know what cases will be covered in the ICMS in 2026. The law firms may need to make preparations for that. Judicial administrator. Well, starting from 2026, when we mandate the use of ICMS, case types under the ICMS, including all case types where electronic mode has been made available in the district courts, and if the second phase of ICMS is implemented smoothly in the High Court, we will include such cases in the mandatory use. And we will prioritize the cases where ICMS is heavily used. We don't have a practical guide yet or a roadmap. When we have it, we will brief the sector on that. So in other words, you don't have a decision yet, and you will look at the situation with the High Court and the usage rate before you reach a decision. Yes, starting from 2026, we will mandate the use of ICMS for some cases, but for district courts, the ICMS has been implemented starting from 2022. There will be a dozen case types where electronic mode have been made available. We'll look at the usage situation during the non-mandatory use phase. Chairman, I hope that my question will not discourage some law firms in using the ICMS, but I wonder if there is a fallback solution or a plan B. What if the mandatory use is delayed? Well, it will not be delayed. When we mandate the use of ICMS, we will set out exception cases. We allow room for the sector to be flexible. What kind of flexibility are you talking about? Well, if the filing is urgent and if at that time our ICMS is down, that's how we allow the law firms to submit physical copies and not use the ICMS. Any other questions? Ms. Maggie Chan, any other questions? Thank you, Chairman. I have one more question. On the fees of e-filing and e-search, for lawyers who search cases that they're not responsible for, they have to download the results. I hope that the fees for downloading and printing can be lowered to encourage people or lawyers to use the ICMS. That concludes the item. Next item, any other business? There being no AOB, meeting adjourned. Thank you.